Chapter 10. The Judiciary. Part 1. Principles governing the administration of justice. Principles of justice. 169.1. The courts are the fountain of justice and the last bastion of hope in upholding, promoting, and protecting the rule of law, thereby ensuring adherence to law and order for an orderly and peaceful society. 2. In administering justice, the courts shall be guided by and observe the following principles. A. Justice is to be done to all without regard to the social, economic, or other status of any person. B. The dispensing of justice must be carried out with efficiency and effectiveness without any undue delay. C. Reasonable compensation must be awarded to victims of wrongdoing committed by other persons and in accordance with this Constitution and other laws. D. It is important to recognize, encourage, promote and strengthen other forms of dispute resolution, including mediation, reconciliation, arbitration, and traditional and community methods of settling disputes, so long as they are not repugnant to justice or morality. E. Justice is to be administered without undue regard to procedural technicalities, and F. The purpose and principles of this Constitution must be protected and promoted. Judicial Authority. 171. The judicial authority of the Gambia is vested in the judiciary and shall be exercised by the courts established under this Constitution and any act of the National Assembly. 2. No person, including the President, National Assembly, and any organ or agency of the state, shall have or in any way or method exercise any power to take or transfer the judicial authority of the Gambia from the courts. Independence of the judiciary. 171.1. The judiciary is an independent organ of the state, and every holder of judicial office is subject only to this Constitution and the law, and in the exercise of judicial power or the performance of judicial function shall not be subject to the control or direction of any other person or authority. 2. The government and all departments and agencies of the government shall accord such assistance to the courts as the courts may reasonably require to protect their independence, dignity, and effectiveness. 3. No organ of state shall directly or indirectly engage in any activity that has the effect of coercion on, hindering, frustrating, or impeding the judiciary in the discharge of its functions. 4. The office of a judge of a superior court shall not be abolished while there is a substantive holder of the office. 5. The remuneration and benefits payable to or in respect of the holder of a judicial office shall A. Be a charge on the Consolidated Revenue Fund, and B. Not be varied to the disadvantage of the holder of the judicial office. 6. The retirement benefits of a retired judge of the Superior Court shall not be varied to his or her disadvantage during his or her lifetime. 7. A member of the judiciary shall not be liable to any action or suit in respect of anything done or omitted to be done in good faith in the lawful exercise of a judicial power or performance of a judicial function. Part 2. Office of Chief Justice and Judicial System. Establishment of Office of Chief Justice. 172.1. there is established the office of Chief Justice of the Gambia, who shall be the head of the judiciary. 2. The Chief Justice shall A. Be a citizen of the Gambia, and B. Be responsible for the administration and supervision of the courts. 3. An act of the National Assembly may provide for the making of rules by the Chief Justice or such other authority as may be specified in the Act for regulating the practice and procedure of the courts. The courts and judicial power. 173.1. The courts of the Gambia comprise A. The superior courts established in Part 3. B. A court-martial established under an Act of the National Assembly. And C. The Magistrates' Court, the Shari'ah Court, the District Tribunals, and such lower courts and tribunals as may be established by an Act of the National Assembly. 2. The superior courts shall, in addition to any other power conferred on them, each A. Be a superior court of record with power to commit for contempt to itself and all such powers as are vested in a court of record, and B. Have in relation to any matter within its jurisdiction power to issue such orders and directions as may be necessary to ensure the enforcement of any judgment, decree, or order of the court. 3. The Chief Justice shall make rules in relation to the supervisory jurisdiction of the High Court and Shari'ah High Court. Part 3. The Superior Courts and Jurisdiction. 1. The Supreme Court. 174.1. There is established the Supreme Court, which shall comprise A. The Chief Justice, and B. Not less than 4 and not more than 12 other judges, at least one of whom shall be qualified in Sharia, and who shall, subject to Section 1183, be citizens of the Gambia. 2. The Chief Justice may, in any particular case where it is expedient to do so, appoint in writing a judge of the Court of Appeal to sit in the Supreme Court for the determination of a particular cause or matter. 3. Where a cause or matter before the Supreme Court involves the application or interpretation of Sharia, and it is expedient to appoint a judge of the Court of Appeal with knowledge and experience in Sharia, the Chief Justice shall appoint in writing such judge to sit in the Supreme Court for the determination of that cause or matter. 4. Subject to subsection 5, the Supreme Court shall, for the purposes of its proceedings, be constituted by an uneven number of not less than 5 judges of the court. 5. A single judge of the Supreme Court may exercise the powers of the court in any interlocutory matter which may be subject to a fresh application to a bench of 5 judges of the court. 6. The Chief Justice shall preside at sittings of the Supreme Court and, in his or her absence, the most senior of the other judges of the court shall preside. 7. The Supreme Court may sit at any place in the Gambia appointed by the Chief Justice. Jurisdiction of the Supreme Court. 175.1. The Supreme Court shall A. Be the final court of appeal of the Gambia. B. Have such appellate and other jurisdiction as may be conferred on it by this Constitution or any other law. And C. Not have original jurisdiction in respect of any criminal matter. 2. For the purpose of hearing and determination of any cause or matter within its jurisdiction, the Supreme Court shall have all the powers conferred by law on any court established by this Constitution or any other law. Supervisory jurisdiction. 176. 1. The Supreme Court has supervisory jurisdiction over all other superior courts and may, in the exercise of that supervisory jurisdiction, issue orders and directions for the purpose of enforcing or securing the enforcement of its supervisory powers. 2. The Chief Justice shall make rules in relation to the supervisory jurisdiction of the Supreme Court over other superior courts. Original jurisdiction. 177. 1. The Supreme Court has exclusive original jurisdiction. A. For the interpretation or enforcement of any provision of this Constitution other than any provision of sections 37 to 67 and 74, which relate to fundamental rights and freedoms. B. On any question whether any law was made in excess of the powers conferred by this Constitution or any other law upon the National Assembly or any other person or authority. C. On any question as to whether or not a person was validly elected to the office of President or was validly elected to or vacated his or her seat in the National Assembly. 2. Where any question referred to in subsection 1A and B arises in any proceedings in any other court, that court shall stay its proceedings and refer the matter to the Supreme Court for its determination, and such other court shall give effect to any decision of the Supreme Court in the matter. Appellate jurisdiction. 178.1. An appeal shall lie to the Supreme Court as of right. A. From any judgment of the Court of Appeal on an appeal in any civil or criminal cause or matter originating from a judgment of the High Court or Shari'ah High Court. B. From any judgment of the Court of Appeal on an appeal in a matter originating from a judgment of a court-martial. C. From any judgment of the Court of Appeal on a petition as to whether or not a person was validly elected at a local government election. D. From any judgment of the Court of Appeal on an appeal against an adverse finding of a commission of inquiry. And E. In such other case as may be prescribed by an act of the National Assembly. 2. An appeal shall lie to the Supreme Court with the leave of the Court of Appeal from a judgment of the Court of Appeal in any cause or matter commenced in a court other than the High Court or Shari'ah High Court, if the Court of Appeal is satisfied that A. The case involves a substantial question of law, or B. It is in the public interest that the cause or matter should be heard by the Supreme Court. 3. The Supreme Court may entertain an application for special leave to appeal to the court in any other judgment of the Court of Appeal. 4. An appeal shall lie to the Supreme Court in any case referred to it in subsection 1, 2, or 3. A. At the instance of a party to the proceedings in the Court of Appeal. B. With the leave of the Supreme Court or the Court of Appeal at the instance of any other person having an interest in the matter, or C. In a criminal cause or matter at the instance of the Director of Public Prosecutions acting in the interest of justice and for the avoidance of abuse of the legal process. Power of Supreme Court to review its decision. 179.1. The Supreme Court may, on application made to it, review any decision made or given by it on such grounds and subject to such conditions as may be prescribed by rules of court. 2. The Supreme Court shall, when reviewing its decision under subsection 1, be constituted by no less than 7 judges of the court. 3. All other courts shall be bound to follow the decision of the Supreme Court on a matter of law. 3. The Court of Appeal. Establishment and composition of Court of Appeal. 181. There is established the Court of Appeal, which shall comprise a. The President of the Court of Appeal, who shall be a citizen of the Gambia, and b. Not less than 4 other judges of Gambian citizenship, at least one of whom shall be qualified in Shari'ah, and who shall, subject to Section 1883, be citizens of the Gambia. 2. The Chief Justice may, in any particular case where it is expedient to do so at the request of the President of Court of Appeal, appoint in writing a judge of the High Court to sit in the Court of Appeal for the determination of a particular cause or matter. 3. Subject to subsection 5, the Court of Appeal shall be constituted by 3 judges of the court. 4. In any cause or matter before the Court of Appeal involving the application or interpretation of Shari'ah, the President of the court shall, to the extent feasible, ensure that judges of the court competent in Shari'ah constitute the court to hear and determine the appeal. 5. A single judge of the Court of Appeal may exercise the powers of the court in any interlocutory matter which may be subject to a fresh application to a bench of 3 judges of the court. 6. The President of the Court of Appeal shall preside at sittings of the court, and in his or her absence the most senior of the other judges of the court shall preside. 7. The Chief Justice may, in consultation with the President of the Court of Appeal, establish such divisions of the Court of Appeal as he or she thinks fit to sit at such places in the Gambia as he or she may determine. Jurisdiction of Court of Appeal. 181.1. The Court of Appeal has jurisdiction to hear and determine an appeal or a petition as the case may be, a. From a judgment, decree, and order of the High Court and the Shari'ah High Court, and such other appellate jurisdiction as may be conferred on it by an act of the National Assembly. b. From a judgment of a court-martial which shall lie as of right to the Court of Appeal. c. On any question as to whether or not a person was validly elected at a local government election, and c. Against an adverse finding of a commission of inquiry. 2. For the purpose of hearing and determining any appeal within its jurisdiction, the Court of Appeal shall have all the powers vested in the court or tribunal from which the appeal is brought. 3. The High Court. Composition of High Court. 182.1. There is established the High Court, which shall comprise a. Not less than 7 judges who, subject to Section 1883, are citizens of the Gambia, and b. Any judge of a superior court whom the Chief Justice may, by writing, request to sit as a judge of the High Court. 2. The High Court shall be constituted by a single judge. 3. The High Court may sit at such places in the Gambia as the Chief Justice may determine, and he or she may establish permanent divisions of the court to sit at various places throughout the Gambia and assign judges of the court to any such division. Jurisdiction of High Court. 183.1. Save as provided in Section 1771A, the High Court has original jurisdiction a. To hear and determine all civil and criminal proceedings, b. To interpret and enforce rights and freedoms provided in Sections 37 to 67 and 74. 2. The High Court shall, in the exercise of its original jurisdiction, have all the power and authority as may be conferred by this Constitution or any other law. 3. The High Court has jurisdiction in appeals from courts subordinate to it, other than the Sharia court as may be prescribed by an act of the National Assembly. Supervisory jurisdiction. 184. The High Court has supervisory jurisdiction over all lower courts and adjudicatory authorities in the Gambia except the Sharia court, and may, in the exercise of its supervisory jurisdiction, issue directions, orders of writs, including writs of habeas corpus, orders of certiorari, mandamus, and prohibition, as it may consider appropriate for the purposes of enforcing its supervisory powers. 4. Sharia High Court. Composition of Sharia High Court. 185. 1. There is established the Sharia High Court, which shall comprise a. Not less than 3 judges who, subject to Section 1883, are citizens of the Gambia, and b. Any judge of a superior court competent in Sharia whom the Chief Justice may, by writing, request to sit as a judge of the Sharia High Court. 2. The Sharia High Court shall be constituted by a single judge. 3. The Sharia High Court may sit at such places in the Gambia as the Chief Justice may determine. Jurisdiction of Sharia High Court. 186. 1. Save as provided in Section 184, the Sharia High Court has original jurisdiction to hear and determine Sharia causes or matters relating to adoption, marriage, divorce, burial, inheritance or endowment (WAF) amongst people who are subject to Sharia in that regard. 2. The Sharia High Court shall, in the exercise of its original jurisdiction, have all the power and authority as may be conferred by this Constitution or any other law. 3. The Sharia High Court has jurisdiction in appeals from the Sharia Court as may be prescribed by an act of the National Assembly. 4. A party to proceedings in the Sharia High Court is entitled to be represented at his or her own expense by a person qualified in the Sharia or by a legal practitioner. Supervisory jurisdiction. 187. The Sharia High Court has supervisory jurisdiction over the Sharia courts and may, in the exercise of its supervisory jurisdiction, issue such directions and orders as it may consider appropriate for the purposes of enforcing its supervisory powers. Part 4. The Judges. Appointment of Chief Justice and other judges. 188. 1. The President shall appoint a. The Chief Justice, other judges of the Supreme Court and judges of the Courts of Appeal, acting on the advice of the Judicial Service Commission after confirmation by the National Assembly, and b. All other judges acting on the advice of the Judicial Service Commission. 2. The appointment of judges of the superior courts shall be by warrant signed by the President and sealed with the public seal. 3. If a superior court comprises less number of Gambian judges to constitute the full complement of the court, a judge who is not a citizen of the Gambia but is a judge in an equivalent court in another Commonwealth country and meets the requirement for appointment under this Constitution may be appointed to the court for such duration as may be considered necessary. Qualification for appointment of judges. 189. 1. A person is qualified for appointment as Chief Justice if he or she is qualified to be appointed a judge of the Supreme Court. 2. A person is qualified to be appointed a judge of the Supreme Court if he or she a. has at least 15 years experience as a superior court judge, or b. has at least 15 years experience as a distinguished academic, judicial officer, legal practitioner, or such experience in other relevant legal or Sharia field, or c. has held the qualifications specified in paragraphs A and B for a period amounting in aggregate to 15 years or more, and D, is a person of high moral character and proven integrity. 3. A person is qualified to be appointed a judge of the Court of Appeal if he or she A, has at least 12 years experience as a superior court judge, or B, has at least 12 years experience as a distinguished academic, judicial officer, legal practitioner, or such experience in other relevant legal or Shari'ah field, or C, has held the qualifications specified in paragraphs A and B for a period amounting in aggregate to 12 years or more, and D, is a person of high moral character and proven integrity. 4. A person is qualified to be appointed a judge of the High Court or Shari'ah High Court if A, in the case of the High Court, he or she is qualified as a distinguished academic, judicial officer, or legal practitioner in the Gambia and has been so qualified for a period of not less than 7 years. Or B, in the case of the Shari'ah High Court, he or she is qualified as a distinguished academic, judicial officer, or legal practitioner in Shari'ah and has been so qualified for a period of not less than 7 years. Or C, he or she has at least 7 years experience as a superior court judge in the common law or in Shari'ah, whether in the Gambia or 1. Other Commonwealth country in which the common law is practiced. 5. For purposes of this section, a reference to a distinguished academic relates to a person who is qualified to practice law in the Gambia, save in the case of the Shari'ah High Court. Vacancy in the Office of Chief Justice. 191. Where a vacancy occurs in the Office of Chief Justice, or if the Chief Justice is for any reason unable to perform the functions of his or her office, the President may appoint the most senior judge of the Supreme Court to act in that office until A, a person has been substantively appointed to and assumed the functions of that office in accordance with this Constitution, or B, the Chief Justice has resumed the functions of his or her office. 2. A vacancy in the office of Chief Justice shall be filled by a substantive appointment within 6 months of the office becoming vacant. Tenure of office of judges. 191.1. Subject to the provisions of this section, a judge of a superior court, A, may retire from office after attaining the age of 65 years, and B, shall vacate the office of judge on attaining the age of 75 years. 2. A judge who is required to vacate office under subsection 1B may continue in office for a period of 6 months after attaining the specified age for vacating the office to enable him or her to deliver judgment or do any other thing in relation to proceedings that were commenced before him or her prior to attaining that age. 3. The Chief Justice and any other judge of a superior court may resign from office by addressing his or her resignation as provided in section 306. 4. Where the President receives a resignation in accordance with subsection 3, he or she shall immediately notify the Judicial Service Commission of that fact, and the Commission may advise the appointment of a replacement. Removal from office. 192.1. A judge of a superior court may be removed from office only for A, inability to perform the functions of his or her office arising from infirmity of body or mind. B, misconduct. C, misbehavior. D, serious breach of a code of conduct applicable to judges. Or E, bankruptcy or entering into an arrangement with creditors. 2. The removal from office of a judge of a superior court may be initiated only A. by the Judicial Service Commission acting on its own volition, or B. on the petition of a person addressed to the Judicial Service Commission. 3. A petition under subsection 2b shall be in writing, setting out the alleged facts constituting the ground or grounds for the removal of the judge. 4. If the Judicial Service Commission, after considering the petition, is satisfied that the petition discloses a ground for removal under subsection 1, it shall send the petition to the President. 5. The President shall, within 7 days after receiving the petition under subsection 4, suspend, in writing, the judge from office. 6. Within 14 days after suspending the judge, the President, acting on the advice of the Judicial Service Commission, shall A. in the case of the Chief Justice, appoint a tribunal comprising 1. a judge of a Supreme Court or its equivalent in a Commonwealth country as chairperson, 2. two other superior judges from separate Commonwealth countries, 3. a legal practitioner of not less than 20 years' experience with high moral character and proven integrity, and 4. one person not being a legal practitioner with not less than 20 years' experience in public service affairs. B. In the case of a judge of the Supreme Court other than the Chief Justice, appoint a tribunal comprising 1. the President of the Court of Appeal as chairperson, 2. two other persons who hold or have held office as Superior Court judges, 3. one legal practitioner of not less than 15 years' experience with high moral character and proven integrity, and 4. one person not being a legal practitioner with not less than 20 years' experience in public service affairs. Or C. In the case of any judge of a Superior Court, appoint a tribunal comprising 1. a judge of the Supreme Court as chairperson, 2. two other persons who hold or have held office as Superior Court judges, 3. one legal practitioner of not less than 15 years' experience with high moral character and proven integrity, and 4. one person not being a legal practitioner with not less than 15 years' experience in public service affairs. 7. A person who is a member of the Judicial Service Commission or has been such a member at any time within a period of 5 years after leaving office shall not be eligible to be appointed on any tribunal established under subsection 6. 8. Notwithstanding section 171(5)b, the remuneration and benefits payable to a judge who is suspended from office under subsection 5 shall be adjusted to 1/2 until such time as the judge is removed from office or reinstated. 9. A tribunal that is appointed under subsection 6 shall A. regulate its own proceedings, B. inquire into the matter concerning the judge in an expeditious manner, C. afford the judge the opportunity to be heard and to be represented by a legal practitioner of his or her own choice, and D. prepare a report setting out its findings and making a recommendation to the President on whether or not the judge should be removed from office. 10. The proceedings of the tribunal under this section shall be held in camera. 11. Where the tribunal recommends the removal of the judge, the President shall so notify the judge in writing, and the judge may appeal against the recommendation to the Supreme Court within 10 days after being notified. 12. If the judge fails to appeal against the tribunal's recommendation within the specified period, or the Superior Court dismisses his or her appeal, the President shall act on the recommendation of the tribunal. 13. If the tribunal recommends to the President that the judge should not be removed, the judge shall A. immediately be reinstated in office. B. Be treated as if he or she had never been suspended. And C. Be entitled to the payment of his or her remuneration and benefits that were adjusted under subsection 8. Remuneration and retirement benefits of judges. 193. 1. A judge of a superior court shall be entitled to such salary, allowances, and other benefits as may be prescribed by an act of the National Assembly. 2. A judge of a superior court shall A. Retire on his or her salary if, on the date of his or her retirement, he or she 1. Has served as a judge of the superior court for a period of not less than 10 years, or 2. Has served more than 5 years but less than 10 years as a superior court judge, and the President, after considering a recommendation from the Judicial Service Commission, approves for the judge to retire on 3/4 of his or her salary, and B. Be entitled to such retirement benefits as may be prescribed in an act of the National Assembly. A judge of a superior court who has not satisfied any of the conditions prescribed in subsection 2 shall, on retirement, be paid a pension and such gratuity as he or she is entitled under the rules governing pension and gratuity. 4. A judge of a superior court who ceases to hold office as a judge for any reason whatsoever shall not appear or act as a legal practitioner before any court or tribunal in the Gambia, but this prohibition shall not apply to a judge who is appointed on a temporary basis only. Part 5. Administration of the courts. Establishment of Office of Judicial Secretary. 194. 1. There is established the Office of Judicial Secretary, which shall be a public office in the public service. 2. The Judicial Secretary shall A. Be a person who is qualified to be appointed as a judge of the High Court, or a person, though not of the qualification of a judge of the High Court, has extensive experience and is qualified to be appointed as permanent secretary. B. Be a person of high moral character and proven integrity. And C. Be appointed by the President on the recommendation of the Judicial Service Commission. 3. The Judicial Secretary shall, subject to any policy, direction, control, or instruction of the Chief Justice, be responsible for assisting the Chief Justice in the administration of the judiciary, and shall A. Be the accounting officer of the judiciary, B. Facilitate the holders of judicial office in the execution of their functions, and C. Be accountable to the Chief Justice for the performance of his or her duties. Administrative provisions. 195. 1. The Chief Justice may issue orders and directions in respect of any matter that relates to the administration of justice, and the Judicial Secretary and all other staff of the judiciary shall comply accordingly. 2. The offices of other staff of the judiciary shall be public offices in the judicial service. Financial matters. 196. 1. The Judicial Secretary shall, with the approval of the Chief Justice, submit the annual estimates of expenditure for the judiciary directly to the National Assembly. 2. The Chief Justice is entitled to appear in person or assign the Judicial Secretary and such other staff as he or she considers fit to appear before the National Assembly to defend the judiciary's annual estimates of expenditure and answer any questions in respect of those estimates. 3. In considering annual estimates of the judiciary, the National Assembly shall not reduce the budget of the judiciary below the amount that was approved for the immediately preceding year. 4. The judiciary shall be self-accounting, and the monies charged on the Consolidated Revenue Fund or appropriated by an act of the National Assembly for the judiciary shall be paid quarterly into the account of the judiciary. Part 6. The Judicial Service Commission. The Judicial Service Commission. 197. 1. There is established a Judicial Service Commission which shall comprise A. The Chief Justice as chairperson, B. One judge of the Supreme Court nominated by that court, C. Two other judges of the Superior Court, at least one of whom is qualified in Shari'ah, nominated by the judges of the Superior Courts other than of the Supreme Court. D. The Solicitor General and Legal Secretary. E. Two legal practitioners of not less than 10 years standing at the Gambian Bar, at least one of whom shall be a woman, nominated by the Gambia Bar Association. F. One person with extensive experience in public service affairs, nominated by the President. 2. The members of the Judicial Service Commission, other than the members referred to in subsection 1A, B, C, and D, shall be appointed by the President, subject to confirmation by the National Assembly. 3. A member of the National Assembly shall not be qualified to be appointed a member of the Judicial Service Commission. 4. Subject to subsection 5, a member of the Judicial Service Commission shall hold office for a term of 3 years and may be reappointed only once. 5. A member of the Judicial Service Commission shall vacate his or her office if he or she ceases to hold the office specified in subsection 1, by virtue of which he or she was appointed, or if he or she becomes a member of the National Assembly. 6. A member of the Judicial Service Commission, other than an ex officio member, may be removed from office in accordance with section 216. 7. The Judicial Secretary shall serve as secretary to the Judicial Service Commission. Appointment of judicial officers and judiciary staff. 198. 1. The power to appoint persons to hold or act in any office specified in subsection 2 shall vest in the Judicial Service Commission. 2. Subsection 1 applies to the offices of A. Master, Sheriff, Registrar, and Assistant Registrar of a Supreme Court. B. The office of Magistrate. C. The office of Shari'ah Judge. D. The office of a member of a district tribunal after consultation with the chief of the district concerned. E. The office of a member of any other subordinate court or tribunal within the judiciary. F. Such other offices of a member of any court as may be prescribed by an act of the National Assembly. And G. Other offices and staff of the judiciary. 3. The Judicial Services Commission, A, shall be guided by competitiveness and transparent processes of appointment of judicial officers and other staff of the judiciary, and B, may delegate the power of appointment to the Chief Justice in respect of junior staff positions. Other functions of the Commission. 199. The Judicial Service Commission shall, in addition to the functions conferred on it under Section 198, have power, A, to review and make recommendations on the terms and conditions of service of the holders of judicial office, other judicial officers, and staff of the judiciary. B, to receive complaints against, investigate and remove from office or otherwise discipline judicial officers and staff of the judiciary. C, to promote and facilitate the independence and accountability of the judiciary and the efficient, effective, and transparent administration of justice. D, to prepare and implement programs for the education of and for the dissemination of information to judicial officers and the public about law and the administration of justice. E, to advise the government on improving the efficiency of the administration of justice. And F, to exercise such other functions as may be conferred on it by an act of the National Assembly. Operation and procedure. 201. In the exercise of its functions under this Constitution, the Judicial Service Commission shall act independently and shall not be subject to the direction or control of any other person or authority. 2. The Commission may make rules and regulations in relation to the efficient and effective performance of its functions, including the regulation of its procedures, conduct of judicial officers, and the administration of the judiciary.